The petitioners are interested persons within the meaning of 91.8 and can seek declaratory orders from this commission. It is proper for the commission to issue declaratory orders for the requested relief and should not abstain from ruling on the petition. The questions presented to the commission are not barred by res judicata or by issue preclusion. 91.8 and 205.2 confer subject matter jurisdiction on the commission to entertain and rule on the three questions presented in the petition. The petition is significant to the orderly administration of Chapter 205 and to prevent indirect subversion of the clear mandate of the law. The statutory language and framework of Chapter 205 provide this commission with the mandate to classify lands into districts. 205.5a recognizes that the powers granted to the counties govern the use of land within agricultural, rural, and urban districts, while the DLNR governs the use of land within the conservation district. The most important word here is within. The counties and the DLNR govern the use of land within a district. They do not have authority to classify lands into districts or to determine whether district boundaries should be amended to reclassify land from one district to another. The authority conferred on the BLNR in 183C3 is to identify and appropriately zone those lands classified within the conservation district. It confers no power on the land board to decide which lands throughout the state should be within the conservation district. That power is solely vested in this commission. The Office of Planning argues that 205.2 cannot be interpreted without reference to statutory provisions not administered by the commission. The power of the commission to classify lands into districts or to reclassify lands into other districts is not contingent or dependent upon statutory provisions not administered by the commission. No other authority of the state is empowered to condition, limit, or define the powers of this commission to classify land into districts. The Office of Planning, UH, and TMT point to a contested case hearing conducted pursuant to the Land Board's power to control land use within the Conservation District and a subsequent decision therefrom for the proposition that such a procedure as well as subsequent judicial review foreclose this commission from ever considering whether lands subject to those proceedings are subject to reclassification. This contention is flatly wrong, and the primary reason why WAMPA and Napapa'i are submitting testimony in support of this petition. Consider this hypothetical. A landowner seeks approval to use 14-acre parcel of land classified in the agricultural district for uses which are appropriately in the urban district. This approval is contested by neighbors and concerned community groups, and county approval may finish my paragraph. And the county approvals challenged unsuccessfully in the courts. Subsequently, neighboring parcels of land in increments of 14 acres or less are converted to similar use so that after 15 of these approvals, there's a 500-acre de facto urban district within an agricultural district. Under the Office of Planning, UH, and TMT's argument, this commission would be without power to reclassify that land because one of these approvals went through a contested case proceeding that rendered a decision on the standards for zoning within that district that was subsequently affirmed by an appellate court. The problem with this contention is that the issue of what district the land should be classified as was not before the appellate courts. An appellate court can only review the case before it, and the case would have been whether the county decision maker complied with the standards for the approval requested. Neither the land board nor the counties have the power to evaluate or determine whether to reclassify the land into a different district. That authority is solely the authority of this commission, and one that is never before the land board and is never before the counties. Act 187 of 1961, in establishing this commission and its powers to classify land into districts, stated, quote, "Inadequate controls have caused many of Hawaii's limited and valuable lands to be used for purposes that may have a short-term gain to a few, but result in a long-term loss. WAMPA and Napapa'i urge you to grant the declaratory orders requested in the petition. Mahalo for the opportunity to provide testimony today."
Thank you. Questions?
Sorry, just a clarifying question. So who is WAMPA and Napapa'i?
WAMPA is the West Maui Preservation Association. It is a West Maui nonprofit organization that's dedicated to preserving, protecting, and restoring the natural and cultural environment of West Maui. Napapa'i Vavai Ula Ula is an unincorporated association of over 5,000 West Maui residents and other shoreline and nearshore users who are concerned about protecting and preserving the quality of life and environment for West Maui communities particularly as it relates to public uses and access of and to the shoreline.
Thank you.
Commissioners. Commissioner Okuda.
Thank you, Mr. Chair. Thank you for your testimony, Mr. Collins. You know, I understand the overall or one view of the situation, which might be summed up as the fox guarding the fox who's eating the chickens, yeah? So I appreciate that. But as an attorney, you do understand the issue of subject matter jurisdiction, correct?
Yes.
That if a body has subject matter jurisdiction, the body or the tribunal, the agency or the court can make a decision about the matter which it has subject matter jurisdiction, correct?
Yes.
But if the body does not have subject matter jurisdiction, then even if the people who sit on that body or agency believe strongly that somebody should do something about the fox, if there's no subject matter jurisdiction, then any ruling by that body would be void, correct?
That's correct.
Okay. And to determine, and the Land Use Commission is not like the legislature, correct?
That's correct.
The legislature can pass laws, and maybe the general public thinks the laws don't make any sense, or maybe the general public think the laws do make sense, but the legislature has pretty broad authority, you know, without violating due process rights, but the legislature has broad powers to make decisions about what takes place in a community, correct?
That's correct.
For-
With some limitations.
I'm sorry?
With some limitations.
Yeah, I agree with that, with some limitations. For example, if the legislature passed a law that specifically said no telescopes are allowed on the summit of what, no, we even shouldn't put it that way. If the legislature passed a law prohibiting the development of certain structures on certain types of lands, unless there was a constitutional violation, that restriction would be upheld in most cases. You agree?
Possibly. I think it would depend on the facts, but quite
Yeah.
possibly.
Well, assuming there's no constitutional violation, probably upheld. When you look at whether or not, or when we try to determine whether or not a body like the Land Use Commission has subject matter jurisdiction over something that's in front of it, we have to first look at what the legislature has said or defined by statute or law as the jurisdiction of the Land Use Commission, correct?
That's correct.
And would you agree that it's HRS section 205-5 that spells out the subject matter jurisdiction of the Land Use Commission?
I think partly, but I also think that it's 205-2, which is what provides, which is the basis of this commission's powers.
Okay. One rule of statutory construction is if the legislature has provided specificity over something, the sections of the law which provide specificity control over more general provisions. You agree with that?
That's correct.
Let me read to you again HRS section 205-5, and I quote, "Except as herein provided, the powers granted to the counties under section 46-4 shall govern the zoning within the districts other than in conservation districts. Conservation districts shall be governed by the Department of Land and Natural Resources pursuant to Chapter 183C," close quote. Did I accurately read that section?
Yes.
Do you believe that that's pretty specific about who governs what takes place within certain districts?
It does address who governs the uses within a district, but it doesn't address the commission's power to classify which lands should be in which district.
Well,
so they're two separate things. So governing use of land within a district is completely separate from this commission's power to classify lands into a district. And while the standards that are used to evaluate what uses should be in which district and which lands should be in that district, there's sort of like a rational relationship between those two things. They're completely different, and the main contention that WAMPA has is that the land board's power to govern uses within districts and the county's power to zone or to govern land use within districts does not limit or in any way interfere with this commission's power to classify which district land should go into. And although there is overlap in terms of considering uses, the powers that are conferred on the counties and the state in this section are subordinate to this commission's power to district, because otherwise the statute would say the land board can also basically irrevocably can trap certain land into one district, and there's nothing in 205 that gives the land board that power or the counties that power.
Can you quote for us specifically the section from the Hawaii Revised Statute that provides that the Land Use Commission can reclassify a parcel of land where the owner of the land has not initiated the request for a boundary redesignation?
The rule that allows for that is 15-15-46(1). It doesn't require a landowner.
Well, can you read where the rule specifically says that the Land Use Commission has authority to basically unilaterally, or as us lawyers like to use Latin words which we don't know what it really means, sua sponte, reclassify a parcel of property where the owner has not so requested?
I'm not sure if the Land Use Commission has authority to sua sponte conduct district boundary amendments.
Well, okay.
If that's what you're asking. I don't
No.
think that you folks have the authority to do that.
Okay, we don't have sua sponte authority, but let me get rid of the Latin word then. Can you quote word for word and give us a citation to the statute which specifically states that the Land Use Commission can reclassify a parcel of property where the owner has not requested the reclassification?
Well, in your rules it says the following persons may initiate a petition to the Commission for district boundary amendment. 1, state departments or agencies. 2, county departments or agencies of the county in which the property is situated.
Okay, and
so it's in your rules.
yeah.
There's like 2 of the 3 people who can initiate a district boundary amendment aren't landowners.
Okay. Has any state department here attempted or requested or initiated a request for a boundary amendment with respect to lands located at the summit of Mauna Kea?
Not that I'm aware of.
Is there any evidence in the record that any county has initiated or filed a request for a boundary amendment for lands at the summit of Mauna Kea?
Not that I'm aware of.
And this is not intended as, you know, like the bar exam question or a law school question.
Oh, and Mr. Okuda, I did find it. It's 205-3.1, which is the statute that says that any department or agency of the state or any department or agency of the county in which the land is situated can petition.
Okay, but there's no evidence in the record that any department or any county has attempted or filed a request to redesignate the lands at the summit of Mauna Kea, correct?
Not in this docket, because it's a declaratory petition.
Okay. Do you have any comment on whether or not the case that has been discussed here, Citizens Against Reckless Development versus Zoning Board of Appeals of City and County of Honolulu, applies specifically as to the question of whether or not a declaratory relief or declaratory ruling proceeding is appropriate in this case?
Definitely not in this case, and as my prepared testimony indicated, holding so would result in an absurd situation where anytime any decision of a county or state agency about any land is done, then the person that controls that land could basically stop the Land Use Commission from ever reclassifying land. I mean, that's, or making a declaratory order that certain areas of land are more appropriately in a different district. And I think that that's not what the holding at Card was very specific, is that the people in Card failed to take an appeal at the appropriate time, and instead they sought to appeal the director's decision through a declaratory petition. But this is not that case, because only a very small portion of the land that's the subject of this declaratory petition is subject to the 2017 contested case and the subsequent appeals. This is the issues that are being addressed in this petition, although I know that UH and TMT are very passionate and emotional about this issue, the petition, the subject matter of this petition is not about them. It's about the use of that entire area as an urban precinct. That's what the issue of this petition is. And so to say that because one small area of this land got some agency approval that was reviewed by a court forecloses this commission from being able to reclassify land would be to abandon the main function of this commission. The main duty of this commission is to determine what is the appropriate district for all land in this state.
Yeah, and thank you. I understand
Sure.
your argument. I do appreciate the fact that one of the benefits, policy benefits of a district boundary amendment is by its nature, it requires more consultation with the community, more impact, and in fact, as this commission recently, a few weeks ago, dealt with the Waimanalo Gulch landfill case on Oahu, you know, I think at least myself and a few other commissioners, maybe more than a few, have a real problem with this kind of incremental types of decisions where in the very beginning there's certain representations, and when you get to the end of 30 years, it really looks different. Okay, so believe me, we're sensitive to that. So let me ask you the last question as someone who also teaches at the University of Hawaii, who has connections with the university, like many of us here on the commission. You were here and heard the representations of the University of Hawaii about promises moving forward. Do you believe those promises?
Well, you know, I would like to.
Yeah.
You know, I would like to, and you know, I'm a person who thinks that actions speak louder than words, and so I think that if the university is going to make promises, I think they need to back it up with some kind of tangible action. And at this moment, I don't.
Okay,
See that.
and
That's with that one. That's only with the one issue. That's a very small part of this,
okay.
the subject matter of this. And that's me personally. It's not Wampa or not Papaya.
And let me ask the final question. What would have to be in your, and this is your personal view, I appreciate you might not be speaking on behalf of your organization, but what do you think is one of the things the University of Hawaii can do to demonstrate that this is not going to be just words and talk, but there really is going to be real action?
You know, I think putting a pause on the current construction plans at the top of the summit to allow there to be a political solution, I think would be the way, and to reference, like the West Maui Preservation Association. You folks had a matter before you when you were on Maui a couple weeks ago, where the West Maui Preservation Association was involved in the docket back 15 years ago, and it's been resurrected by a new owner. And you folks recessed, you didn't make a decision on the request to allow the landowner to work with the community groups, and that's what WAMPA and the other community groups have been doing since you guys basically paused a final decision. And you know, I think that the University of Hawaii, it would serve them well to de-escalate the situation and to bring the real stakeholders to the table and figure out a political solution, because otherwise, but that's, I think, probably beyond the scope of this, And that's just my personal feeling. I don't have any authority from Wampa or Napapai to bind them to that.
I appreciate your testimony. Thank you very much. Thank you, Chair.
Commissioner Ohigashi.
I had only 2 cups of coffee this morning, and I just want to be sure I got the analogy right.
In an agricultural district, through some procedure, a landowner gets 14 acres of land. They're seeking approval for some special use that really is an urban use, but they're going through that process. And the neighbors and the community groups get involved. They oppose it. It gets approved. It goes through the courts. The appeal is unsuccessful, and so that 14 acres is essentially allowed to engage in an urban use, but it's in the agricultural district. Well, once that happens, then 14 acre by 14 acre, suddenly you have a 500 acre area that's a de facto urban district, but it's still in the agricultural district. And if the Land Use Commission got a declaratory order petition saying and the Land Use Commission were asked to say that the use of this 500 acres should be in the urban district, the argument of the Office of Planning, or one of the arguments of the Office of Planning, because they argue alternatively, but then the arguments of UH and TMT is because that one case that dealt with one small part of this larger area of land had been subject to a county approval that was affirmed by the appellate courts, then that ousts the Land Use Commission of its power to reclassify lands, or the ancillary power, which is to issue declaratory orders that some factual situation is appropriate for some agency action. And I think that can't. It's an absurd result from the theory. And I understand for the TMT issue, people are very passionate about it, and that UH and TMT feel very strongly about it, but I think that the legal theory that they're propounding is not suitable generally for the commission.
And this is just a comment, and I like your analogy because now I understand it, but I don't think it quite fits within the factual or the scheme that we're talking about today. We're dealing with a conservation district that is not statutorily within the Land Use Commission purview, versus your analogy deals with an agricultural district, which is specifically identified as a Land Use Commission. So I don't see the analogy quite working out, and it leaves me with the same question that has been in my mind as to whether or not those 2 separate districts, or whether or not we can identify or determine uses within the conservation district to this declaratory order. And you don't have to answer that. It's just my comment. It's just that the analogy just doesn't fit in my mind, so that's my comment.
Okay.
Commissioner Giovanni.
Thank you, thank you, Chair. Mr. Collins, I'm just trying to grasp an understanding of your basic contention regarding the authority of this commission. So let me give you a hypothetical. Let's go to the other end of the spectrum, and let's take a district that has been classified as urban, downtown Honolulu, fully developed. Is it your contention that this commission has the authority, if it so chooses, on its own, to reclassify that as conservation? As stupid as that may be.
Well, I think, the commission doesn't have standardless discretion. And that's, I think, the issue that Commissioner Ohigashi is grappling with. Because standardless discretion, yeah, and I think because, and I disagree with Attorney General Yee, that the districts are not simply, the difference between the districts is not simply that there's different regulators or different regulations. 2052 makes it very clear what should be in each district. And that decision of interpreting 2052 is with the commission. And so I think the question of could the commission designate lands that have been fully urbanized, that are in the urban district, could this commission reclassify it into the conservation district? I think generally, yes, the commission has the power to reclassify lands from one district to the other, but I think in evaluating what the legislature has picked to be for each of the districts, I think that there might be an issue there that probably could or would be challenged.
And that authority that you contend that we have to reclassify, is it furthermore your contention that we can do that without a third party bringing forth a petition to reclassify?
No, I think in order for land to be reclassified into a different district, that there needs to be a petition to amend the district boundaries. What's being asked in this petition is not to change the district boundaries, but to make declaratory orders that would be the proper thing to do. So it wouldn't, I don't think this petition is asking the commission to declare that, and I understand that the chancellor, who is new to Hawaii and doesn't have a legal background, said yesterday that regardless of what the commission does, in this proceeding, that the UH Hilo is not going to seek a district boundary amendment. But I also know with my own legal practice that generally the government will follow the law. And so I think if this commission makes a declaratory order that it is suitable or proper for a district boundary amendment to be sought, that I probably think that she'll either be overruled or there'll be reconsideration, at least some thought put into that. I think it's just because it's not her area of expertise and she's new that she maybe...
Can you speak right into the microphone? I noticed some people struggling to hear.
I'm sorry. I just said that I just think that because she's new to Hawaii and she doesn't have legal training, that I think it's just... I don't think that you guys should take that to mean that the University of Hawaii is going to basically thumb its nose at the commission if it decides to issue one or more of the declaratory orders. At least I hope that the university would take seriously.
Thank you, Commissioner Giovanni. Commissioners, the first question, let me start with this. Given your considerable legal acumen, if you were supportive of seeing the TMT built on the summit of Mauna Kea, can you construct an argument by which it would make sense for the university to pursue urban redistricting?
Well, I think partly the problem is that UH's interest is actually different than TMT's in a broader sense, but because everybody's sort of in this bunker mentality right now, it's like everybody's merging. Everybody's merging, so there's like this bunker mentality. So I actually think it would, I mean, if I were with UH, I would actually file my own declaratory order petition or seek a district boundary amendment.
Why is that?
Well, at the minimum, because there is this question. These are our industrial uses. Scientific laboratories are throughout the United States under American zoning principles is an industrial use. And so to get some clarity from this commission, I think is a very sensible thing to do. So at the minimum, if I were UH, as soon as this petition was filed, I probably would have worked and filed my own, so that and tried to address the issues in the manner that was probably most suited to UH, but that wasn't done. Or alternatively, petition for a district boundary amendment, and I mean the commission can also state whether or not that's appropriate or suitable. They can deny a petition for a district boundary amendment and say it's not proper. But I think partly because of the TMT issue, which is a small part of the land that's under consideration here, that there's sort of this bunker mentality going on and everything has to be a either or, and there's no consideration of the broader issues, especially to UH's interests, which are not identically aligned to TMT's.
Thank you. can I ask you to comment on the question which I raised to a number of the other parties of whether or not the conservation district use permitting process allows a comprehensive and cumulative look at land use on the summit?
Well, I think if we want to use the example of the TMT contested case, I didn't represent anybody in that. I wasn't a party. Sorry, didn't represent anybody in that.
You can
and
move
I
the
wasn't,
microphone closer
sorry,
to the.
I wasn't a party to it, and I didn't represent anybody. But from what I was able to read and from reviewing some of the transcripts, it seemed that Judge Amano made it very clear that the issues that are basically within the power of this commission would not be considered in that, and were expressly not allowed to be considered in that. And so if those things aren't being considered, then I don't see really how the issues of the cumulative impacts and the issues of not just the project itself, but all of the projects surrounding it are being considered as a whole in the way that this commission is supposed to consider that.
Thank you. My third might be more of a comment. I would tend to agree with the concern you expressed over Attorney General Yee's, Deputy Attorney General Yee's characterizations of the districts. Because the districts aren't named the really difficult to develop district, the sort of difficult to develop district, the pretty easy to develop in district, and the do whatever you want district, right? They're urban, rural, agricultural, and conservation.
I understand the point he's trying to make and it's unfortunate that that TMT has so much gravity that this issue is getting drawn directly to it as an example as opposed to other things. But you folks see land developers all the time and their projects, and I'm sure that every single one of them would love to have deputy attorney generals and UH counsel and this whole army of attorneys come up with clever ways of indirectly getting around what normal people that come to you folks can't get around. And so I think even from the perspective of the business community and investors and developers, it's quite unfortunate that one or two entities get selected for special and uneven treatment. And I think the consequence to that in an economic sense is that it actually drives up transactional costs tremendously, because then people think if they can get some special edge in with certain favored state agencies and they don't have to go through the normal process that everybody else has to go through, that is actually an alternative. I know on Maui, and part of the reason why WAMPA is so interested in this petition is because what we have seen in West Maui is that all of Pioneer Mills lands south of Lahaina town is now one giant suburb of residences, all on agricultural land. And it's precisely because of this thing where what cannot be done directly through this commission is being done indirectly by urbanizing lands that are not in the urban district through these end runs. And so that's why, from WAMPA's perspective and Napapai's perspective, it's so important that the commission distinguish between the classification and reclassification of lands into districts and the separate power and subordinate power of the counties and the state to govern the uses within the districts.
Right, the way the land use law is set up is that we have these 4 districts, and then there's this acknowledgement that, sometimes lands or uses are situated in a place that, doesn't quite fit into the districts it's in. And so in the ag district, we have this special use permitting process that also applies to the rural district. Obviously, you don't need that special exemption in the urban district because everything's allowed. And then in the conservation district, we have the conservation district use permitting scheme. But in the law, it does say that if it's over 15 acres, right, that permit has to come to us for review. There's no sort of review process set into the statute for the CDUPs. So I'm trying to understand to what degree can we look at, there's no case law to my knowledge on CDUPs compliance with LUC land use designations. There is case law on the granting of agricultural special use permits, and in fact, for the Y&I board case, rejecting the use of those permits and saying, no, that's actually an urban use, you need to redistrict instead. So help me understand why we might look at those cases to interpret what should apply here, given the differences in the way the law is constructed.
I slightly disagree with Commissioner Ohigashi with respect to, I slightly disagree with Commissioner Ohigashi's saying that my example doesn't exactly apply, because the fact that the Land Use Commission deals with special uses in the agricultural district for lands that are over 15 acres that is not the power that the Land Use Commission exercises when it decides that some area of land needs to be classified not in the agricultural district but the urban district. So it's not because you folks have the power to issue special use permits for lands that are over 15 acres, which gives you folks the power to classify lands. They're completely separate. And so that's why I think that my analogy is identical, because the power that is addressed in both the petition here and in my analogy is the Land Uses Commission's power to classify. And in the Waianae Neighborhood Board case, that's actually an example. It wasn't that the issue was not that the Land Use Commission, it was that the wrong power was being exercised, not that there's some joint power. The counties do not have joint power over classifying lands into different districts. There's no joint power. It's exactly the same as the land board. There's no joint power between the counties and this commission, or the land board and this commission, with respect to classifying lands.
Thank you. My last question. You've argued, some might believe persuasively, that we have this duty and power to defend our powers and authorities. If the commission chooses to not issue, chooses to state that we do not believe that we have the authority to rule on this declaratory order, what would the consequences of that decision be?
Well, one possibility is that you'll be subject to an appeal. But I mean, that's probably, regardless of what happens, this is very likely going to end up in the courts. But I think, you know, what has happened on Maui is that, well, as the example of south of Puamana, you basically have a giant suburb that's on in an agricultural district. And so I think what it does is it signals to market participants in particular that there are these, that if they get the right lawyers or they think it out the right way, that there are ways to get around, if they do it indirectly and not directly, that they basically can get around the commission's regulatory powers and oversight. And I think that's probably the biggest danger. And you know, and it's really not a good, I mean, even for people in the business community, it's not a good way of conducting business, because then what people do is they try to become the favorite of the person who's going to, in government, who's going to help them through indirection, instead of going through the normal process that everybody else has to go through. And so that's, I think, the danger, more than the more practical danger, more than anything else, if the commission doesn't clarify its powers and the issues that are before it, the questions that are before it.
Thank you.